and welcome to the FedTalk Forum webinar call. Today, January 15th, 2025, we are delighted to host a Courthouse Steps oral argument program on Free Speech Coalition versus Paxton, which was argued earlier today before the court. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the expert on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief, certainly more brief than his distinguished career would deserve. So I would highly recommend you check out his impressive full bio at fedsoc.org. Today, we are fortunate to have with us Eric Jaffe, who currently serves as a partner at Sher Jaffe LLP. Prior to coming to Sher Jaffe, he ran his own practice from 1997 to 2018. And before that, he served as a clerk to Justice Clarence Thomas, and also spent 5 years in litigation practice in the Washington, D.C. law firm of Williams & Connolly. Mr. Jaffe has been involved with appeals in a broad range of legal issues, including First Amendment challenges to campaign finance reform, Commerce Clause challenges to healthcare reform and other federal legislation, Equal Protection Clause challenges to affirmative action in education, First Amendment challenges to school vouchers, Fifth Amendment challenges to takings of property, and a variety of other matters. He's represented businesses and nonprofit groups, judges, senators, former government officials, and has been involved in over 120 Supreme Court matters, including filing cert petitions, representing half a dozen parties on the merits, and filing over 70 amicus briefs. We're grateful to have his expertise today. I'll leave it there regarding an introduction, but one last note before I get off your screens and we move into a time of opening comments. If you have questions throughout the program, please do submit those via the question and answer feature, which is found at the bottom of your Zoom screen, so it'll be accessible when we get to that extended portion of today's webinar. With that, thank you all for joining us today. Mr. Jaffe, the floor is yours.
Thank you very much, Chella, and thanks, of course, to the Federal Society for having me. I always enjoy doing these, and I always appreciate the opportunity to talk to folks about First Amendment issues in particular. So today's argument in Free Speech Coalition versus Paxton about the constitutionality, or more importantly, about the proper standard for assessing the constitutionality of online age verification requirements for sexually explicit materials. It was interesting. I thought there was quite a bit of consensus that everyone seemed to agree that porn, particularly more aggressive porn, is bad for kids. No surprise there. The harder question is, how does one go about stopping kids from accessing porn online in today's modern society where everyone has a cell phone, while still allowing adults who want to go online to do that without risking the privacy implications and the security concerns and other things that would happen with age verification if you were required to show an ID. That's the basic issue. The narrow issue in this case was really just whether you should apply strict scrutiny to that question, or whether, as the Fifth Circuit had held, only rational basis scrutiny applies. And I think, just to give you a precursor of the answer to that is likely to be that rational basis is probably not a sufficient level of scrutiny, even for some of the justices who would take a more favorable view of Texas's law, but that you may not see a full-blown level of strict scrutiny. And the problem boiled down to a clash between two different sets of cases. On the one hand, you have this older case, Ginsburg, which said minors basically have no right to access sexually explicit materials, and so someone who allowed minors to access such materials in a bookstore or sold to minors in a bookstore could properly be prosecuted for doing that and having not, verified that they were not in fact minors in a reasonable way. The other line of cases, of course, are cases like Ashcroft and Reno, Playboy, and a bunch of cases that talk about age verification requirements to access sexually explicit websites can burden and chill the speech and access to speech of adults and of the speakers, and consequently have to be reviewed with what in most of the cases looked like strict scrutiny, though in one or two it's a little ambiguous, but in none of them was it actually rational basis scrutiny as it related to the burdens on adults. So I think what you will see is the court, by some fractured ruling, vacating the Fifth Circuit's decision that rational basis applied, suggesting either that a slightly lower standard of scrutiny, perhaps intermediate scrutiny, should properly apply given the brave new world of technology, or suggesting that even if rational basis applies, it applies in a different way where some of the speech is unprotected as to some people, but protected as to others. And that's really the interesting rub in this case, is here you have speech, the content of which is protected in some instances and unprotected as to another class of listeners. And so the dividing line between protection and non-protection necessarily turns on the content of the speech, in addition to the age of the viewers or listeners or readers. And that is an interesting dilemma that cuts against the traditional content-based dividing line between strict and other types of scrutiny, where here the content itself is in fact the reason why it's unprotected as to minors. So with that precursor in mind, let's just talk about what some of the justices hinted at via their questions. Justice Thomas, I think, suggested that he is open to age verification in some form, though I don't think he necessarily played his hand one way or the other regarding whether or not this particular category of age verification passes muster. And I think he is open towards reconsidering the standard in cases like Ashcroft and Reno about whether it needs to be strict scrutiny. There were a number of questions he asked that suggested that he would be quite content if the government took the position, if the U.S. government had changed, took the position that it has historically taken, that only intermediate scrutiny applies. For years, the U.S. government had taken the position that intermediate scrutiny should apply. It lost that over and over and over again, and finally threw in the towel in defending the Child Online Protection Act. I believe that was the Reno case. Justice Thomas joked with them at one point, to a lot of laughter in the courtroom, that the government shouldn't have given up so easily. So I think that perhaps gives us some indication that he is open to a slightly different standard for reviewing these kinds of things, particularly for child pornography and online pornography, or child access to pornography, not child porn, which of course is illegal for everyone. But I mean child access to otherwise non-obscene pornography. That he is open to something more like intermediate scrutiny rather than strict scrutiny. He asked a lot of questions about, does the changing technological landscape mean that the standard should change, that we should be a little bit more accepting of government efforts to deal with the technological challenges posed by smartphones and every 15-year-old being able to hack around their computers, their parents' efforts to block their access. So I think he is probably safely in the category of suggesting that there has to be some way for states to deal with this problem, but I'm not sure he's going to go all the way to the extreme of rational basis scrutiny. I could easily see him suggesting either intermediate scrutiny or a lightened application of strict scrutiny. Justice Alito, I think, was the most ardent defender of Texas in the questioning, and was uniformly hostile to the notion that the challengers could distinguish the Ginsburg case, which involved, a question of what you could do to forbid minors from accessing good old-fashioned, pornographic magazines in a brick and mortar store, and seeing very little difference between the leniency that Ginsburg showed towards government efforts to restrict minors' access to brick and mortar stores with Texas's effort to restrict minors' access to online stuff. And did not see a tremendous concern with the potential chill of adults, finding that there was a similar chill when you had to walk into a bookstore, and if you looked anywhere near the line between a minor and an adult, perhaps even have to show your ID. I think he is as far on to the Texas side of the equation as was possible, and asked a lot of very interesting questions. I mean, there's no question that back in the day before internet access to online, adult materials, it probably took some gumption to walk into an adult bookstore or an adult movie theater, because even if they weren't taking pictures of your ID, there you were standing out in public potentially recognizable by passersby and by whoever else might be working there or going there. What I found interesting that Justice Alito raised was whether or not, because the lack of protection for minors' access to adult materials turns on the content of the materials, as it necessarily must, as in any obscenity case, even for adults, whether or not that altered the usual test for content-based restrictions, given that here the content in some sense drives the lack of protection rather than the heightened protection. And that tension, I thought, again, was quite interesting. Chief Justice Roberts, I think, was interesting as well, and leaning in a little bit of the direction of maybe you need a different standard given the modern technological developments, but only asked very few questions, once again wondering whether or not advances in technology means we should adapt the standard of review accordingly. He asked that question twice to different parties, but did not really follow up a lot on that, didn't ask a lot of questions, so he's a little harder to read. But again, falling into what I suspected was an inclination either to adopt intermediate scrutiny or to at least point out that strict scrutiny, as applied to a conceded, compelling interest that inherently turns to some degree on the content of the materials, might somehow have a different application of strict scrutiny. And I could easily see him going into that category. Justice Gorsuch, similarly, I thought was a bit hostile to the position of the petitioners, the porn purveyors in this instance, suggesting that why should the standard be any different than for a brick and mortar store like in Ginsburg, and wondering why this case was distinguishable from the Ginsburg case, which again is the walking into a adult bookstore for minors. There was a lot of back and forth on that, a lot of focus on the fact that ID requirements are now pervasive in modern society for all kinds of things, from gambling, online gambling, to voting, to online purchases of tobacco, to alcohol, obviously. The petitioners try to distinguish that, of course, as none of those involving First Amendment activity, and voting being somewhat different, that you only get to do it for yourself. It's a little bit of a different kind of First Amendment activity, perhaps. But again, I thought that the questions themselves suggested how Justice Gorsuch was leaning and sort of looking for ways to distinguish the later cases that applied strict scrutiny from the sort of heartland case represented by Ginsburg of, if you're allowed to stop minors from accessing adult materials, how else are you going to do it but by checking to see if they're actually minors or not, and therefore by making sure that the adults who come in aren't minors. And that seems to be the focus of his concerns. Justice Kavanaugh similarly had those kinds of concerns, but also, I think, was focused on other doctrinal issues, like how effective do the less restrictive alternative need to be? Because the petitioners in this case were pointing out that there are a variety of less restrictive alternatives than age verification, including sort of content blocking software that parents could adopt, that you could adopt at the ISP level, other forms of age verification that did not involve personally identifiable information, and suggesting that this law didn't actually go for those, etc. And Justice Kavanaugh, I think, was looking to ask the question about, even if an alternative is less restrictive, does it at least need to be as effective as the more restrictive alternative? What happens if it's less restrictive but also less effective? And that is a question I thought interestingly goes to the merits more than to the formal question presented about what standard should be applied. But it looked to me like him looking for a way to look at strict scrutiny and wonder whether or not, as applied in this case, strict scrutiny might be somewhat less strict than perhaps in other contexts. And that was a good instance of that, I thought. He was also more concerned overall with whether or not the court needed to rule on the other issues raised by a request for a preliminary injunction, i.e. the likelihood of success aspects of it, rather than merely the standard under which that likelihood of success was to be judged. And there was a lot of back and forth about whether or not Texas's law could indeed pass strict scrutiny, and whether or not this court should reach out and comment on that, or at least comment on whether or not it was unclear whether it could pass scrutiny, and hence, therefore, a likelihood of success was hard to prove one way or the other, and hence no injunction. I think at the end of the day, he was more concerned with what would happen if you sent it back saying, well, the Fifth Circuit got the standard wrong. It's certainly not rational basis. It's something else, something at least a little bit more strict than that, if not full-blown strict scrutiny. What would happen then? And I think you saw that among the number of justices worrying about whether or not the preliminary injunction would suddenly spring back to life if the court vacated the Fifth Circuit decision. And at the end of the day, I think all parties agreed that at some point, either the court could make clear that the stay pending appeal could remain in effect, even if the preliminary injunction needed further analysis. And so vacating that portion of the Fifth Circuit judgment, but allowing a stay while further proceedings continued, or at a minimum, that the state of Texas could certainly ask the Fifth Circuit to reinstate the temporary stay of the injunction while it reconsidered the appeal under the new Supreme Court standards, whatever they might be. But that seemed to be a big part of Justice Kavanaugh's concerns. And in particular, it sounded to me like a concern with preserving the law while the further litigation progressed. Justice Barrett, I think, had similar concerns about modern technology and the resourcefulness of kids in getting around other forms of less restrictive alternatives and why this therefore might be required. But she asked, the thing that she added uniquely, I think, to the conversation was a concern, a macro concern with diluting different aspects of Supreme Court jurisprudence. So if you were going to apply strict scrutiny to this kind of restriction, but say, but it probably passes because, you know, it's kids and everything, that would dilute strict scrutiny as it applied to other cases. And so it's very much of a dilution argument that would hurt strict scrutiny, not in the porn context, but in other contexts. And that was a very interesting set of questions, but also how one would go about deciding whether this was truly a content-based restriction, given that, like I mentioned before, the lack of protection for children's access to adult material is inherently content-based. And so you heard her ask a question, for example, about City of Austin, which talked about whether restrictions that depended upon the content of a billboard were in fact content-based, and the court held they're not necessarily content-based. And so there was some debate about which part of the First Amendment gets diluted. If you say this isn't really content-based and therefore doesn't require strict scrutiny, are you diluting the content-based principles of First Amendment law? Or by contrast, if you're saying it doesn't require strict scrutiny, but passes muster, no worries, you're diluting strict scrutiny. All very interesting, but again, I think pointing towards an inclination to try to find some middle ground that might look like intermediate scrutiny, whether formally or in practice. And from her perspective, presumably formally would be better than just applying strict scrutiny. I mean, applying intermediate scrutiny, but pretending that it was strict. So I could easily see from her an inclination, not unlike Justice Thomas's, to formally change the standard of scrutiny for these things, given the inherent differences between children's access to adult materials. Justice Kagan, I thought, was also somewhat interesting on these issues, though perhaps a little more sympathetic to the petitioners. You know, again, wondering how this is distinguished from brick and mortar and whether or not you would apply strict scrutiny to brick and mortar access questions like, can kids go into adult bookstores or X-rated movie theaters or strip clubs or things like that? And how is it that we would now have to evaluate age verification for those venues under strict scrutiny as well? And could they possibly pass muster, et cetera? So she was very concerned with what is the line for triggering strict scrutiny. Again, perhaps looking for some way of letting some age restrictions get through, even if you wouldn't let all age verification requirements get through under any and all circumstances. She echoed, I thought, interestingly enough, and talked to the United States in their amicus role about some concerns the United States had raised that made it hard for the United States to take a position on the ultimate merits. And those were quite interesting. The concerns at issue were the triggering criteria of the Texas law, which is that 1/3 of your materials have to be adult oriented, implying potentially that the 2/3 of your material that were protected could still be put behind an age an age wall. And the United States didn't know how Texas would interpret their law for that. We got an answer to that later on from Solicitor General Nielsen on behalf of Texas, saying that no, if you segregated the adult material, the rest of your website would be fine as long as you put just the adult material behind an age verification wall. But he concedes that there has been no ruling from the courts on that. That's just his interpretation and how he thinks it should be properly read. The other question that she was concerned with is what age verification methods are available? Do you need to show an ID, a government ID, or transactional history that would have plenty of personally identifying information? Or were other potentially less invasive methods that are commercially available out in the market, but not necessarily permissible under Texas law? How would Texas law interpret those other methods, like biometric identification? So we look at your face, we can tell that you're not a child, and so you can go through even if we don't need to know your name. That they talked about is biometric ID. And again, Solicitor General Nielsen suggested that he believed that that was permissible under Texas law, but again, there's been no rulings. The Fifth Circuit, of course, thought that that was permissible under Texas law also. And that's an interesting question, whether such biometric identification really and truly does pose less of a threat of personally identifying information getting out there, particularly in an age of facial recognition technology. But be that as it may. And then the final question I think was most interesting was when you say something, the material needs to be obscene as to minors, i.e., appealing, not appropriate for minors. Which minors are you talking about? Because some things that would be inappropriate for a 3-year-old or a 5-year-old or a 7-year-old might be perfectly appropriate for a 17-year-old, and hence not obscene as to them. And that was an interesting question as well. Once again, Solicitor General Nielsen suggested that the test was for all minors, and hence you would have to measure it on the basis of a 17-year-old, because the test would be, no redeeming value, social, political, scientific value, for any minors. And he thought, therefore, if something had value for a 17-year-old, it would not trigger Texas's statute. Once again, no court cases on that from Texas, but that at least was the position that he advocated and said would apply. Finally, I think between Justices Sotomayor and Ketanji Brown Jackson, they were the most skeptical of Texas's law, and in particular, were focused very closely not on what the outcome would be, but on what the standard of review would be. And were very much protective of the standards in Reno and Ashcroft and Playboy and some of the other cases, and very skeptical that Ginsburg, the brick and mortar case, actually went so far as to suggest that rational basis applied regardless of the burden on adults. They both, I think, suggested that there might well be things that could pass strict scrutiny, but were laser focused on the narrow question presented as they saw it, which was, what's the standard? Should it be rational basis or strict scrutiny? And both were quite clear that they thought strict scrutiny was the right answer, and that all of these other concerns with technology and burden and harm to kids all went to the application of the strict scrutiny standard and whether or not one might indeed pass strict scrutiny rather than to which standard should apply. So with that, I think there's a pretty solid chance that the court says in a multi-part opinion that rational basis is not the way to look at this in toto, that given the at least potential and likely burdens on adults, one has to do something more, but potentially that something like intermediate scrutiny could apply, because if you're allowed to stop kids from accessing this material, you ipso facto have to have a way of sorting the kids from the not kids, and you have to let states do that somehow. And you can't just say that's impossible, given a compelling interest and the lack of protection vis-a-vis kids of this kind of material, and in particular of kids having a First Amendment right to access this material. That's, I think, where the net result's going to be. I think you'll have different theories of how to get there, whether it's you could apply strict scrutiny, but some states might actually win, even though we don't know if Texas would, or whether you have a push to change the standard to intermediate scrutiny as more realistic and non-dilutive of genuine strict scrutiny. Either version of that would be quite interesting. The final thing I'll say is there were a few interesting points worth noting in the argument. One was the notion of the privacy concerns and the interest of adults and who might have access to identifying or age verifying information, whether that information be driver's licenses or whether that information be biometrics, and in particular, whether the state itself would have access to such information. Because of course, giving the state access to such sensitive information, even about adults, opens up a huge privacy can of worms and concerns with improper use, as we can see with all kinds of privacy issues, whether in the tax context or whether in the donor disclosure context. And certainly any adults would be concerned of a hostile state having access to their adult viewing habits. The other thing I think was interesting was Solicitor General Nielsen's seeming concession that you have to judge the materials at issue according to the oldest minors, not the youngest minors. Again, that's not a court ruling, but it's an interesting concession. I'm not sure it's really one that he could be held to in future cases, but I thought it was interesting. I also thought it was interesting how he went to some lengths to tout the reliability and true concern of the Texas courts. I think many people, perhaps on the other side, are deeply skeptical of how the Texas courts would apply this and whether or not they would be particularly sympathetic to the First Amendment concerns, no matter how well protected, of adults seeking to access sexually explicit material. There was a lot of skepticism, obviously, by petitioners and plenty of the amici, I suspect, about whether this was really the thin edge of the wedge to ban porn even for adults. And Nielsen went out of his way to try to rehabilitate the image of Texas courts, that they would be honest brokers of this. I'm not sure he necessarily succeeded in persuading the skeptics, but I thought that was interesting that he made the effort. The next thing that I thought was interesting was there seemed to be pretty common concern that just flat out rational basis scrutiny in this context might be too lenient. Because of course, if rational basis scrutiny applied, you could just ban porn even for adults, because under rational basis scrutiny, that's a rational way of keeping it out of the hands of minors, given the circumvention methods many minors have about getting to adult-oriented sites by using VPNs, by faking ID, by whatever it is that they would have to do to beat the restrictions. And I think there was a discomfort with going all the way to rational basis. I thought the issue I mentioned earlier about dilution, whether you're diluting the standards of rational basis or diluting the standards for what is and isn't a content-based restriction, I thought that was quite interesting. And then finally, I thought the measures of whether something was or wasn't less intrusive, and how effective it had to be, even if it was less intrusive, all raised very interesting First Amendment points that, while not necessarily squarely going to be at issue in this case, will come back to haunt later stages of this case. So with that, I am happy to take questions and expound further on things that the audience would like me to.
Well, thank you so much. Really appreciate that summary of oral argument, as well as how we got here and the breakdown of each justice. We do have audience questions coming in, and here I'll issue that brief reminder that if you have questions, you can submit those via the Q&A feature. Our first audience question concerns the potential outcomes of this case and asks, doesn't a ruling other than strict scrutiny mean that courts will be back to determining what is obscene, and did that come up in arguments?
Could you repeat? Courts will be back to determining whether something is obscene?
Yes, unless the Supreme Court says this is a strict scrutiny matter, it will then put all courts back into trying to determine what is obscene.
I think that's an apples and orange question, because whether it's strict scrutiny or whether it's intermediate scrutiny, they have to decide whether something is or isn't obscene anyway. And even under the Texas law, the standards for obscene as to minors mirrors the standard for obscene as to adults, with the sole exception of adding in the 3 words "as to minors" after every one of the adult tests. So courts inevitably will be deciding what is and isn't obscene based on community standards, based on prurient interest, based on whether or not there's any redeeming social, political, or scientific value. Those standards exist today, will continue to exist, even under strict scrutiny. So even if the court says, no, we think strict scrutiny still applies, there are very few people who deny that substantial chunks of the material on a site like Pornhub are obscene as to minors. It's just very difficult to get around that. And so at the end of the day, that issue is not as big a deal in this case. In other cases, it will be a big deal, but it won't be a big deal because of the standard of review. It'll be a big deal because obscenity gets treated differently one way or the other, right? If it was non-obscene, full stop, nobody doubts this would be strict scrutiny. If it was non-obscene, even as to children, the age verification requirement would fail miserably. The only thing that makes this even a question is that it is obscene as to children, which means you have to decide what material is covered.
Got it. Thanks so much. Next question relates to the actual question at issue in the case. Despite the fact that we got a lot of discussion of the merits, the question posed to the court assumes a tiers of scrutiny test. Yes, it's what level of scrutiny should be applied?
Yes, the question posed to the court was very straightforward. It's whether the Fifth Circuit erred by applying rational basis scrutiny instead of strict scrutiny as previous cases, according to petitioners, had required. Now, the tier, the phrasing of the question suggests a certain skepticism of tiers of scrutiny, which I am sympathetic to. Certainly, in like the Second Amendment context, I've been complaining about this for a while. So yes, there is implicitly a little bit of a debate about whether or not tiers of scrutiny per se should be just thrown overboard, and we should go to a history, tradition, and text kind of analysis. And you heard a little bit of history and tradition argumentation from Solicitor General Nielsen, but at the end of the day, Texas has not asked that tiers of scrutiny be thrown overboard, and in fact has claimed to be consistent with both the Ashcroft line of cases, the Reno line of cases, and the Ginsburg's line of cases, and are not asking for those to be overruled. So I don't think you will see that here. I think you will only see a debate as between which tier should apply rather than whether tiers should go away full stop.
Got it. Thanks so much. We did. So this next set of questions sort of play into the fact that we did get a lot of discussion of sort of the merits of the case, regardless of the fact that that was the question posed to the court. Given that back and forth, and particularly the back and forth concerning the potential less restrictive means that could be available, I think we had filtering being built into the device, potentially having ISPs do it, or Yoti being put forward. Could you give a brief recap of sort of that part of the conversation? And did we get an answer as to what would suffice to fulfill Texas's law, or whether there was no capacity to have this sort of age gating without highly invasive?
Right. Sure. So there was a lot of discussion of what I would think of as the merits rather than merely the standard. Some of that discussion came in the form of, well, given that technology is so different and therefore the considerations are so different, is strict scrutiny really the right answer? Which I think conflates the two questions somewhat, as a number of the justices pointed out. But in terms of whichever standard you apply, would Texas win, or could any state ever win? Yes, there was a lot of discussion about less restrictive alternatives and whether kids can circumvent one version versus the other. And I thought that was quite interesting. There was no conclusive answer to that, other than Justice Kavanaugh hinted quite strongly that he didn't think the state had to solve the entirety of the problem, and thus was unmoved by under-inclusiveness kinds of arguments. And he didn't think that a less restrictive alternative necessarily was fatal if it didn't solve the problem as well as age verification. So I think in that instance, he's again hinting a bit at how he might view the merits even under strict scrutiny. But no, there was no resolution of that. And in terms of the burdens on adults, the privacy burdens, the cost burdens, no, there was no definitive resolution of that either. I think the justices, somewhat hostile to petitioners, weren't overly concerned with the burdens on adults, on the theory that even in the brick and mortar context, there's somewhat of a burden of having to flash your ID at a adult movie theater or a bookstore or a strip club or whatever it is. So there wasn't a lot of concern there. And in terms of Solicitor General Nielsen, I think trying to mitigate the less restrictive alternative arguments and the overbreadth arguments, he gave his view, which admittedly is the view of the executive branch, or at least seems to be the view of the executive branch in Texas, but was quite candidly conceded that no court has yet ruled on that. No Texas court has yet ruled on that. The Fifth Circuit ruled on it a little bit in terms of what would satisfy the age verification requirements, but of course that wouldn't be binding on the Texas courts. So no, there isn't a resolution of the factual side of the debate, how technology helps or hurts the debate, whether technology both means it's easier to have verification, but harder to have privacy, et cetera, et cetera. I think that will be remanded. I don't doubt for a second that you will hear opinions, comparing opinions, even potentially the majority or plurality opinion, giving all sorts of guidance in what I would call dicta about how courts might think about this. But no, there will be no resolution of that, I don't think, other than encouragement from either side to, to take into account changing technology and realities of kids with smartphones.
Got it. Looping together a couple of questions on the content side of things. One questioner asks whether or not there was a distinction or a conversation on whether or not there was a distinction between brick and mortar or physical and the digital space regarding mediums. Is there a argument to be made that there's a difference in the nature of the content, given that this is digital pornographic content versus the physical content that was addressed when porn is free speech? That line of precedent came out. And related to that, is this a settled question / was that raised at all in the oral argument?
Not from the perspective of the content per se. There was a discussion of digital versus non-digital in the sense that because it's digital, access is easier and it's harder to keep kids out. And so, yes, the digital nature of that, the ubiquity of the technology, the ways of circumventing other safeguards. Yes, obviously, some bouncer at the door who sees a 10-year-old it's not very hard for that bouncer to say, sorry, you can't come into the strip club. But it's a little harder if you have a smart 10-year-old who knows how to use a VPN to stop that 10-year-old from getting into Pornhub. So that it was the medium was talked about, but in terms of how it bore upon the content per se, no, there wasn't a lot of discussion about, oh my God, porn today is so much more awful than porn back in the day, where we thought something was prurient that today we would think was mild. No, there wasn't much discussion of that. There was a brief discussion, certainly in the briefs, of how the material today is meaningfully more aggressive than old-fashioned notions of what constituted pornography. But I think that goes more to the question of some of that material could theoretically be obscene even as to adults, not just to kids. And if it's obscene as to adults, well, then the burden on adults of not accessing it is zero or functionally zero. But again, would not answer the question of the methodology of distinguishing adults from kids as to everything else that is not obscene as to adults. So no, the specific content distinctions didn't come up in quite that way.
Got it. Relating to the discussion about the strength or lack thereof of the record investigating less restrictive means, and this is a broader question beyond simply this case, who typically bears the burden of creating that record? Is it the government or the lawmakers, or is it the challengers to the law? And is that affected by the fact that this is a facial challenge versus a as-applied challenge?
So there was a lot of discussion about whether, as a facial challenge, this should be viewed differently, and whether the burden rests with the challengers. I think at the end of the day, much of that collapsed back to, well, that's really a question for remand, and we probably can't be ruling on that one way or the other. And then on remand, who bears the burden? Somewhat depends on the level of scrutiny you're applying. If it's rational basis scrutiny, then there's no question the challengers would bear the burden in that instance, but would undoubtedly lose anyway. If it's intermediate scrutiny, the challengers have probably a burden of coming forward. But after that, I think the government probably bears the ultimate burden of proof that its means is narrowly tailored and that it's attacking a real problem, and that its solution has a meaningful gain in solving that problem. Even if you think about traditional commercial speech intermediate scrutiny tests, the government bears a considerable burden in showing that its method of solving its problem has some hope of being effective. If it's strict scrutiny, I think once the challengers show that there's a First Amendment burden and at least some plausible alternatives that would be less, facially less burdensome, the burden probably does shift to the government in that instance to have a credible record of why they can't do it any other way but this, and why they've taken their best efforts. And it's sort of why I think in the courts below, there was not a lot of real dispute about if this truly is strict scrutiny, Texas loses. If it's something other than strict scrutiny, well, that's a different ballgame. But I don't think it's very plausible to say that even under sort of true traditional strict scrutiny, Texas could carry its burdens. And I think the challengers probably put forth plenty in the record, and the district judge found plenty in the record to suggest a meaningful burden that would trigger the heightened scrutiny.
Got it. Next audience question relates to, I think, the second of the three questions that the government had put forward concerning, is this all minors or is it just a subsection?
I think that was the third of those concerns the government had.
Thank you for
Which minors are we
clarifying.
talking about here? Yeah.
Was there discussion, reading the question, of the First Amendment rights of minors to access some possibly offensive material? Or was everyone comfortable with the idea that only adults have First Amendment rights? I'll insert of this type.
So implicitly there was, by the very fact that the government was concerned about this, there was a little discussion by the Petitioners Council about, obviously, if you're going to measure this all by what's offensive as to a 3-year-old, then the answer is everything. Whereas if you're measuring it based on what's offensive to a 17-year-old, there's plenty of stuff like sex education materials that have value for a 17-year-old, certainly have social and scientific value to a 17-year-old, but that you would never hand to a 3-year-old. And so, yes, there was some discussion like that. And I think all of that concern is built into Texas's definition, depending on how you read their definition. Because the definition has to be offensive as to minors, has to violate community standards as to minors, and has to have no value as to minors. And if the minors you're talking about are 17, the answer is, well, it's not offensive as to a 17-year-old. There's obviously some value here. And most communities, even in Texas, probably think it's okay to let 17-year-olds read romance novels, even if they're a little steamy, but may not think so much about your 3rd grader or your 3-year-old. You're not going to read them the bedtime story that you would let your 17-year-old read, perhaps. Maybe you would. I don't know. It's Texas after all. So yes, there was discussion, and I think all of the discussion assumed that 17-year-olds have First Amendment rights that are more expansive than the First Amendment rights of 3-year-olds, precisely because more material would not be obscene as to them, even if it is obscene as to a 3-year-old.
Thank you. Last question on the sort of difference between what was actually covered in the question before the court. Is the reason we got so much conversation on the merits instead of just what level of scrutiny should be used, in part due to the fact that the petitioners requested a reinstatement of preliminary injunction? And I'll add a footnote. What are they asking for there, and how would that happen?
So while the question presented was simply, did they use the right standard, the petitioners indeed asked the court to provide a little more guidance. I suspect, fearing that regardless of what standard, on remand, the Fifth Circuit's going to turn around and say, okay, strict scrutiny, they win anyway, and appeal it again, see what happens. Good luck with that. I think there's a not trivial concern on the part of petitioners that that's the way the world's going to pan out if there's no further discussion. And so they asked for more, conceding that the court was not obviously obliged to go beyond it, but that the court, in the interest of judicial economy, might want to foreclose such gamesmanship, such potential or feared gamesmanship. I don't want to impugn what the Fifth Circuit would actually do. I'm just suggesting that there was some concern about what they might do. So that's how it came up. And they were asking that the court sort of say, once strict scrutiny is applied, it's obvious that the preliminary injunction survives, and then it may or may not survive for a final injunction, but that the likelihood of success was pretty strong if you think strict scrutiny applies in the ordinary way. And they're probably right about that. And the only question here is, will strict scrutiny apply in the ordinary way? And I think the Supreme Court, while probably not doing it for the reasons the petitioners wanted, may talk about the merits quite a bit, because they do want to signal that whatever standard they apply, that some version of age verification requirements need to be okay. Because otherwise, Ginsburg is sort of a dead letter on the internet. If you can't stop kids by figuring out who's a kid and who's not a kid, well, then how do you have Ginsburg? So I think you'll see some discussion about technology, about burdens, about how one goes about doing this and how one should think about that, even apart from the nominal standard of review.
Well, thank you. Turning then from oral argument to the potential ramifications of this case, you've flagged here's where you think the court could be going with either intermediate or a watered down or restricted. But I'd love to run a couple of the hypotheticals, starting with what happens if the court embraces full strict scrutiny? What implications does that have for the scope of strict scrutiny, and could it have effects in other contexts?
If the court says strict scrutiny, strict as ever, full stop, like political speech, we're just whole hog, which they're never going to say, by the way. But if they said that, it seems to me that the likelihood of success is self-evident at that moment, that the injunction should kick back in, and that, yes, Texas still has an opportunity to build a record on why they might be able to satisfy strict scrutiny, but it is hard to imagine the statute as it stands surviving it, though it's not so hard to imagine a more narrowly tailored statute theoretically surviving even strict scrutiny. As long as you maintain the position that obscenity as to minors can be restricted, that minors can be stopped from seeing things that are obscene as to minors. If that is the core kernel of something that can't be gotten away with, then yes, some statute will pass strict scrutiny. It just may not be this one. If they say strict scrutiny but don't really emphasize and we mean it, I think, yes, you will see a dilution, a context-specific dilution of strict scrutiny, very much, by the way, like you've seen in half a dozen other circumstances. You've seen it in many of the campaign financing cases where it used to say strict scrutiny and then applied intermediate scrutiny, but they pretended like it wasn't intermediate scrutiny. You saw it in a lot of the affirmative action cases until recently, where we used to say it was strict scrutiny, but it never was. So yes, you will see a context-specific dilution of strict scrutiny, but quite frankly, I think the horse is out of the barn on that one, and we have been reluctant to apply true strict scrutiny for a long time to things that we are sympathetic to the underlying concerns. And some of that may be what's driving a move away from tiers of scrutiny at all, because we haven't really been horribly consistent in applying the tiers, and it just seems like a Rorschach test. And so maybe that's why there's a move towards text history tradition and trying to do something different.
Thank you. I'll ask the reverse question. As much as you said that was highly improbable, you might think this is even more so. What are the implications of this case if the court upholds rational basis as the way to go with this one?
I think if it's truly rational basis and the burdens on the adults sort of don't count in that calculus, then yeah, it's a slam dunk. Texas can do this and much more. If we apply traditional rational basis scrutiny, think economic regulation, well, then there's Texas doesn't have to prove a thing. They can just have a reasonable speculation as to why it might be that way, and then Texas can do whatever they want. But by the same token, just as we have monkeyed around with strict scrutiny in contexts that we don't like the answer, we have monkeyed around with rational basis scrutiny in contexts where we're a little hinky about the answer too. Think Obergefell, where Justice Kennedy kept saying, "Oh, I'm just applying a rational basis," when what he was doing looked a lot like intermediate scrutiny to anyone paying attention. Which is not to say whether it should have been rational basis or intermediate scrutiny, but what it does say is rational basis scrutiny got screwed up too, because we didn't quite like the answer there either. And so I could see the same risk if they say, oh, it's rational basis scrutiny, but lots of things wouldn't be rational if you applied intermediate scrutiny and thought they weren't rational. You could see them blurring the distinction between rational basis and intermediate scrutiny, much like I think you see in Obergefell and related cases.
Got it. Assuming the court comes out as you've suggested, how does this case fit with the other set of free speech / technology cases we've had over the past couple terms? And what might that mean for broader conversations on free speech and technology moving forward?
I think the short answer is it fits uncomfortably with them, but the more realistic answer is it's porn. And so the spillover to other aspects of social media, particularly think the net choice cases, won't be so easy because here at least you have material that nominally is not protected at all as it applies to kids, right? So obscenity as applied to kids. And that's just different than other social media cases where no one's arguing that the content is somehow unprotected. They're just arguing that the terrible harms from the content are awful, or that it hurts the children, even though it's not obscene as to the children. Now, the harder questions will pop up when you get to things like, well, social media rots the brains of kids. And so if porn is harmful to kids in a way that takes away protection, why isn't developmentally putting a spike in their head through screen time just as regulable? And I think you will certainly see plenty of states making that argument, and plenty of people who dislike social media making that argument. I think there is less of a historical basis for it. And I think making the analogy, making the leap might go too far for some of the justices who will be more hostile to porn than they will be hostile to kids wanting to do dance videos on TikTok or whatever replaces TikTok once we ban it. Red Note, perhaps straight up to the Chinese themselves, or maybe Meta's Instagram that will have Reels instead of TikToks. So I think some of their justices might be less hostile to the damage to children from that than they are hostile to the damage to children from obscene materials as to kids.
Okay. Well, I usually start wrapping up with a question on, can you give me a read of how this is going to go? You've already given me that, so I'll push it a little farther and ask, what do you think the breakout will be in the majority opinion and concurrences or dissents as to who is breaking out where and what the key issues at play will be?
I think you will see Justices Sotomayor and Ketanji Brown Jackson, at a minimum, saying it's strict scrutiny. It's conceivable you could pass strict scrutiny, but remand and let Texas prove its point. And if all the concessions they've made about how they've narrowed this law and other means of complying that are less burdensome, et cetera, well, then let them prove that up down below. But that's not our job here. Our job is just to tell you the standard. So I see at least 2 votes for that, with some notion that some law of this sort could pass muster. We just don't know if this one does, and let other people worry about that. You might get some buy-in on that from one other justice, but I kind of feel like even if someone like Kavanaugh came in and said strict scrutiny, he would say, but the way strict scrutiny applies to this is different given the obscenity component of it, meaning some of the speech at least is unprotected at least some of the time. And so you'd have strict scrutiny, but you'd have strict scrutiny as applied to a more novel context. I likewise see Justice Alito and possibly Justice Gorsuch sort of saying, this is just Ginsburg. We implicitly endorsed age verification in Ginsburg, and there's no reason to therefore hold that age verification per se is subject to strict scrutiny. And whether this goes beyond the inherent burdens that we endorsed in Ginsburg, sure, we can remand for that, but it certainly doesn't look like that. And so the likelihood of success doesn't seem very high. So on the 2 polls, I see those 2. And then everyone in the middle, I really think are going to lean towards either saying that past cases did not predetermine the standards on the borderline that didn't require strict scrutiny in every instance or for all aspects of the law, or say, let's just put a new standard in because those cases depended on a view of technology that's just not true anymore. And so their core assumptions went away. And so we think either a milder version of heightened scrutiny, like we used to call it, or flat out intermediate scrutiny should apply. Though it's hard to see someone outright overruling a past case. There will be some gymnastics about why this is okay, other than Justice Thomas, of course, who would say, yeah, the government just gave up too early. Those weren't really strict scrutiny cases and should never have been. And I would overrule them given the opportunity. But in the meantime, don't get too strict with your strict scrutiny. You could see that from him because his view of precedent is you don't have to follow crazy precedent. And he would probably think it's crazy to not. I think it will be driven by this notion that applying strict scrutiny to age limits on theaters, bookstores, and strip clubs would impose way too much of a burden on states that have historically regulated bookstores and strip clubs, at least, and theaters.
Okay. Last audience question, then we may wrap a minute early. Do we have a sense of when we'll get a decision in this?
My feeling is it will take a while because I think there will be a multiplicity of opinions, and that just takes a while. Unless, Roberts or someone else negotiates a simple, it's not rational basis scrutiny. We don't have to decide whether it's strict or kind of strict or something else, but it's certainly not rational basis remand. And we'll get to those other questions later. You could see a per curiam that said just that, but my gut says there will be, 8 opinions or 7 opinions, and that takes a while to write. And given that the injunction has been stayed, and the Fifth Circuit has vacated the injunction, the law can go. You're not stopping the law from going into effect anyway. And so, if they're going to be sympathetic to Texas, there's no need to rush it.
Got it. Well, sorry, feel free.
No, and I don't feel like there was that much sympathy to the petitioners that they would feel the need to rush it, as opposed to write a better opinion rather than write a hasty opinion.
Sounds good. Well, any final thoughts / comments on the case?
No, I think it's all quite interesting, and the most interesting part of all of it is what do you do to speech that is protected and unprotected literally at the same time, and how do you page off the one side from the other when the content is identical? And that's a very hard question to figure out. And the modern technology concerns that the court was grappling with cut both ways. It means it's harder to keep kids away from stuff that we used to keep them away from with some facility. And also the privacy concerns are overwhelmingly magnified based on government or hackers having the information all about your very private adult reading proclivities. So there you go.
Well, thank you. Really appreciate it. Especially appreciate you carving out this much of your day and giving us your valuable expertise and insight. Thanks also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.